All right. Well, good evening, Henny. Can you hear me? Hello. Good to see you in person, Henny. And welcome everybody to the launch of the South African Medico Legal Reports. This is the live session. We will be just for the program for the evening. We will be running a video which I've prepared on the South African Medico Legal Reports themselves. We're then going to hear from Professor Henny Klopper about assessing non-patrimonial damages. And then we've got 3 additional guest speakers, one of which is Ross Shepston, Advocate Ross Shepston from the Joburg Bar, Advocate Ferdinand Kerhan from the Pretoria Bar, and then Conrad Mashelwane, who's an obstetrician and gynecologist who will be talking to us. The event this evening kicks off the first of 3 events, which will be run the end of January, end of February, and end of March, and I'll explain that in the video. So this is the first phase of the launch of the South African Medico Legal Reports. And then we are also, this video session will be available on demand. We've had a lot of requests for whether it's available on demand. I think Sunday evening, people are getting ready for work and what have you. But it's a good time for us to record. And so this is the best time for us to record this video. Everybody's available at this time. But that video will be available on demand and will be sent out via social media channels. We'll also edit the video and send that out via social media channels as well. So it's a great feeling to launch the South African Medico Legal Reports. You will see that there's a South African Medico Legal Reports system, and then, of course, the Medico Legal Reports themselves, which I have my copy with me. Just get it the right way around, and there it is. And we're very, very pleased with what the publishers have come up with. It's a beautiful volume. It's hand cut and individually sewn sections. We've done well so far off the initial pre-launch print run, which we had. We sold out. And we've had a lot of interest in both the Medico Legal Reports themselves and in the system, which I'll explain this evening. So it's very encouraging. We will become more active now over the next few weeks. But I think without further ado, I just want to extend a special welcome to Henny. Henny, nice to see you. Thank you so much for joining us. We really appreciate it.
Bonjour.
Thank you, Henny. Thank you, Henny. And then we've got, I think Ross Shepston is with us already. Ross, welcome to you if you're with us.
Hello, Ian. Yes, I am. Can you hear me?
Yes, I can hear you. Thanks, Ross. Thank you very much. I see Lance Marais. I'm just going to stop his video. Just going to give it a few minutes for people to join us. We're getting quite a few people joining us now at the moment. And I think what we can expect to happen will build up over the next half an hour or so. And then we might find, for those that want to move on at some stage, this video, as I say, will be available on the YouTube channel. What we will do is on our weekly update email, we'll put links to the YouTube channel and the various videos that will be available on demand. So I want to check whether any of the other guest speakers have arrived yet. Just give me a moment to check that. We've got quite a few people have joined us now. I'm not sure whether I don't see any of the other guest speakers. If anybody's available, please just let me know. There's Conrad. Hello, Conrad. Welcome to you.
Advocate Ian Dutton, thank you for the invitation. Looking forward to getting some insight into this South African Medical Legal Report. Thank you.
Thanks, Conrad. Yeah, we're looking forward to hearing from you as well. And I know we've got some events coming up together over the next few weeks from the healthcare side. You'll see Conrad, I make a few remarks in my video about the healthcare side of things. And I do talk about organizations. I must tell you, you and your organization are one of the people that I had in mind when we get the healthcare training going. And we're going to ask you for some input. And let's put some training together between our 2 organizations. And that'll be a really interesting, exciting project to get involved in.
Looking forward to that. Thank you.
No, brilliant. Okay, excellent. All right. I don't see any of the other guest speakers. They'll arrive, I'm sure, fairly soon. But I think just for those that are here, I don't want to delay it too much. We are programmed. My presentation is approximately half an hour. I think that Professor Klopper's presentation will probably be, it sounds to me, around about the 45-minute mark or so. Henny, is that about accurate?
Yeah, that's more or less it.
Okay, and then we've got three Ross's. I know is around about 10 to 15 minutes, and I've got a pre-recording from Advocate Ferdinand Kerhan. His pre-recording I think runs into almost 20 minutes or so, 16 minutes, and then we will also speak to Conrad in between those presentations. So very pleased that everybody's joined us. I see Ferdinand Kerhan has joined us. Ferdinand, good evening to you.
Hello and good evening to everyone.
Yeah, excellent. Okay, I had a look at your presentation. It's available. Everything's loaded. Fantastic. It's in fact already my presentation and Ferdinand, your presentation already on the YouTube channel. I just want to extend a welcome, besides the guest speakers, to all those that have taken some time out on a Sunday evening to watch the launch and express an interest. You know, the thing is with each of these participants, it's a very exciting start for us because each participant represents a network and an organization. And, you know, we're just getting the ball rolling here with the Medico Legal Reports. We've had tremendous feedback with our weekly updates. We're up to over 550 subscribers now on the email side. So we're very pleased with that. We've also had a lot of good interaction. I think there's about 5 organizations that we are now talking to and going into collaboration with. So that's also very, very promising. And we will get the ball rolling, particularly between now and then the next presentation at the end of February. But I think without any further delay, I'm going to then start the launch of the South African Medico Legal Reports. I'm going to go straight into my presentation. If you'll just give me a second to set that up. I just want to check that the sound is going correctly and what have you. And then we can go straight into my presentation. All right, so this is an introduction to the South African Medico Legal Reports professional support system. I just want to say that we've chosen the Compass because that fits in with the professional support system. You'll hear, I've already shown you the South African Medico Legal Reports themselves, that beautiful volume that I showed you. That volume forms one component of a broader support system. And you'll see that system fits into an overall picture, and the Compass is there because it's a guide for practitioners, whether expert witnesses, legal representatives, or medical practitioners, as to the various principles which govern their practice relating to medico-legal work. And I will take you through that system and how it works with over the next few slides. And firstly, let's just start off with let's define what is the South African Medico Legal Reports. Well, it's an integrated system for medico legal practitioners, providing information, training, and awareness using a variety of innovative resources while drawing on traditional professional values and standards. You can think of it as a professional guidance tool through the legal principles of medico-legal practice. Just one or two things I want to unpack there. So it's an integrated system. You'll see that the way we do it is we take different components of that system and we put it together. And we aim at 3 specific markets, which are the healthcare practitioners, expert witnesses, and legal practitioners. And there we provide information, training, and awareness in an integrated approach. When we say we use a variety of innovative resources, you'll see that one of the core concepts of the Medico Legal Reports is to use cutting-edge technology. We've got a lot of information coming at us, and our approach is the traditional ways of absorbing that information. In other words, merely through a textbook, simply can't cut it in the modern environment where information is coming at you from a variety of platforms. We need to use that technology to be able to repackage that information and make it easily accessible to practitioners so that practitioners can get proper guidance as they're busy practicing. But we draw on traditional professional values and standards. Now, what do we mean by that? Well, the traditional values and standards we believe should form an integral part of what we're doing. There's no need, just because the technology is changing and the way that we absorb information is changing, for our traditional standards to be compromised. In fact, on the contrary, our view is that those standards should be improved and elevated through these types of platforms. As I mentioned, this is the first phase. So this launch is the first phase of a 3-phase launch of the South African Medico-Legal Reports. Tonight, we've got the launch of the South African Medico-Legal Reports Launch Edition, which is the volume which I showed you. That's really the flagship edition of the Medico-Legal Reports, and there's a support structure built around that flagship edition. Then we've got the launch of the Quantum Guidelines. That's on the 23rd of February this year. On the 23rd, you'll see the last Sunday of every month, we do a launch. The Quantum Guidelines is a very interesting and exciting project. That is the, if you like, the general damages division of the medico-legal reports. In other words, that's the Professor Klopper is going to talk about non-patrimonial loss. This fits in very nicely with that talk because the Quantum Guidelines deals with the assisting in the assessment and the approach to general damages. And you'll see that there's some innovations which we introduce in that book. It's a very exciting project. I'm really enjoying working on that. One of the reasons is that general damage is extremely important because it runs through every single case we do. Whether it settles or not, there's almost without exception, there's a general damages component, which means that there needs to be an assessment with respect to every single case in respect of general damages. Then we've got, thirdly, at the end of March, we've got the launch of the specialized training program. Now, that specialized training program, I must just explain, I'll get into this in a few minutes in some more detail, but that is going to run alongside, we've already got a current awareness training which runs already with the medico-legal reports, and that's a weekly update and training update on cases that are coming through the system already. But at the end of March, we're going to be presenting a number of specialized training courses, and we're talking to a number of very high-profile individuals. We've made considerable progress with that. A few of them are present this evening, and we're hoping that we can make some announcements soon as to that specialized training program. It's going to be very exciting. And the key with the specialized training program is you want to work with organizations to prepare tailor-made training for those organizations. Let's have a look at why the South African Medico-Legal Reports Professional Support System was developed. Now, I've touched on it, but let's get into a bit more detail. The South African Medico-Legal Reports Professional Support System was developed in response to the increasingly complex and demanding professional medico-legal environment, and in particular, the need to assimilate an increasing volume of information and the associated professional skills in an efficient, effective, and manageable way. And I want to just dwell on that for a moment. You know, there's a real disconnect these days between the volume of information which is being produced by the courts. We monitor about 50 cases a week, which are relevant in one way or another to medico-legal practice. Now, that includes the substantive law, it includes procedural aspects, and it also includes evidential aspects. And if you take those cases which deal, for instance, with the rules of court or with interlocutory proceedings or execution, and then the medico-legal cases themselves, evidence, all of that together, we look at about 50 cases a week. I would estimate there's about approximately 15 cases per week which are relevant to medico-legal practice. So what we do is we distill the information in those cases and we make it available, because it's impossible for a practitioner to stay on top of those cases, simply not possible. However, there's a wealth of very interesting information and useful information locked up in those cases. In every case where the principles are discussed, there's usually a background to that principle, which gives a deeper insight into that particular topic, and we'll explain how we deal with that at the Medico-Legal Reports in a minute. Let's move on to how the SAMLR Professional Support System works. Okay, let's have a look at an overview of the structure of the SAMLR system. The information component, the training component, and the awareness platform. So there are three main components to the South African Medico-Legal Reports system. As I say, it's an integrated solution. So those three components are all integrated and cross-pollinate. So information informs the training informs the awareness, etc. As far as the information is concerned, we provide relevant, accessible information. In other words, we read the cases, we distill the key principles, and we make that available to practitioners in an accessible format. Then, insofar as the training is concerned, it's a practically focused training. We don't want to compromise on the quality, of course, but our focus is practical. We want to provide practically useful training with a good academic and jurisprudential rigor. And then I just want to talk about the awareness platform. Now, the awareness platform, very important component in this modern day. There are two aspects to the awareness platform. The first one is internal awareness. In other words, that's what we call subscriber awareness. In other words, when you're a subscriber to the Medico Legal Report system, we let you know about information through the internal awareness. And then you get external awareness. What that is that's the marketplace's awareness of the subscriber's skills and training. In other words, if you do a course with us or you do training with us and you get a certain accreditation, we make that shareable on social media. You get a certificate. That certificate can go onto your LinkedIn profile. It can go onto your Facebook profile, your WhatsApp, whatever you're involved with. You can then demonstrate your training and your skills to the marketplace. So that's your external awareness. Then the last point I want to make in this connection on the overall structure is the focus which we have is on the law as it is, not policy. In other words, we refer to black letter law. It's a little bit of a loose way that we apply it. But what we mean by that is the law as the judges pronounce it to be. We are not a platform to discuss what the law should be or the social issues around the law or what's desirable or not. There are other platforms for that. There are other institutions for that as to how the law should develop, etc. Obviously, some of that will come onto the platform. But primarily, we are a platform to focus on what the law is and in other words, to guide practitioners as to this is the black letter law, this is what you need to do, this is the current state of play, if you like, and we give guidance on that. We will integrate with other organizations and individuals insofar as what's desirable in future, but we take a snapshot of the law as it is today. All right, then let's have a look at the SAMLR, the information component. This is the first sector. Firstly, the case law system. Very important to understand that the case law system consists of two components. Firstly, the unreported judgments, and secondly, the South African Medico Legal Reports judgments that are actually included in the South African Medico Legal Reports. So the unreported judgments, what we do is we have a look at the judgments coming out of the courts. Any judgment that is relevant to medico legal practice, we will include as a first phase in the unreported judgments. Of those unreported judgments, we will then select those judgments which are worthy of inclusion in the South African Medico Legal Reports volume itself. So then those judgments will then become reported judgments. Both of those categories sit on the website. So even the unreported judgments are on the website, and they are very thoroughly indexed and referenced. So, for instance, we've got reference to the names of the advocates that appear in those judgments, the names of the judges, and the legal principles which then link across to the practice notes themselves. Speaking of the practice notes, that's the next point of the information. What are the practice notes? It's effectively a distillation of the principles as discussed by the courts. So on any particular subject, we have the practice notes, and then that then will be a distillation of that particular topic and cases that have dealt with that topic recently. Then the next point is the quantum guidelines. The quantum guidelines, as I've mentioned to you, we've discussed that already, but the quantum guidelines also forms part of the information sector of the South African Medico Legal Reports. So let's have a look at how they're locked together. You've got your unreported judgments, your reported judgments, South African Medico Legal Reports reported judgments, practice notes, which is the topics dealt with, updates, in other words, to let the subscribers know that something has been updated on the site, and then training, which forms an important component of the overall system. Then if we have a look at, let's have a look at the passage of the cases, just to give you an understanding of how this works. We have the judgment handed down by a court. The next phase is we select the judgment. If it's relevant to medico-legal practice, we format it and publish it on the site under the section judgments, which is in fact unreported judgments. The practice note is updated to include the key principles in that judgment. It's very important because, in other words, for practitioners, they don't have to read the whole case. They can simply go to that section of the practice note, get the principle, and they're updated with regards to that principle, and very easy and simple. How do they know that the practice note has been updated? There's a judgment and practice note notification in the weekly updates. The update section also sits on the website, and I'll show you a screenshot in a moment. So at any time, you can go to the website and look at the update section, but we also do that weekly update. The next phase is that the updates are then included in the current awareness training. And then the final phase is the question as to whether that particular judgment goes into the medico-legal reports or not. So there's the process of the judgment. The judgment gets distilled, put on the website in the practice note and in the judgment itself. Notification is given to the subscriber, and then that is then incorporated in the training. And what this means is that as you're doing your current awareness training, you are automatically up to date with a very wide variety of subjects relevant to medico-legal practice. Very, very important for law firms, very important for advocates. It's a good way to stay up to date. And then, of course, with our awareness, we will then tell the broader public what qualifications you've got, what skills you've acquired, and whether you're up to date with your current awareness training. This is a screenshot of the South African Medico-Legal Reports homepage. The main menu at beginning table of contents, practice notes, judgments, South African Medico-Legal Reports training and updates. You'll see that that is really where everything that I've been discussing, that's the home for those different sections. And you'll find that in those various sections. So let's just have a look then at, I've shown you the copy of the South African Medico-Legal Reports itself. That's the text version. There are two subscriptions. That's the print subscription. You'll get the quarterly volume of the South African Medico-Legal Reports. That's the launch edition we're looking at. Okay, then let's move on to the South African Medico-Legal Reports Quantum Guidelines. I just want to spend a little bit of time on this. So we're still on the information sector. I don't want to call it a quadrant because I think that's inappropriate when you've got three sectors. As I said, the launch on the 23rd of February. We have what we do in the quantum guidelines is, again, from the practitioner's perspective. These guidelines have been put together with practitioners in mind. Expert witnesses will be particularly interested in the assessment factors. What we've done is we've had a look at various assessment factors used internationally. Now, what do we mean by assessment factors? These are clinical factors to be considered by experts, by attorneys, advocates, and judges, but as a first port of call by experts. Those are factors to be considered in respect of each particular individual injury. We like the way that the Irish system approaches it because it to us makes sense. It seems to be comprehensive, and it does dovetail fairly nicely with the South African approach. There are some accommodations which we've had to make, but by and large, it fits quite easily into our system. Now, what's important to stress with the assessment factors is there's no value that is relevant to South Africa because, of course, in Ireland, they work in euros. In Britain, they have a very similar system, but that's in pounds. But we don't look at the value given to a particular injury. We are interested in, at this level, at the clinical factors to be considered. So there's a comprehensive approach to the injury itself, and there's some structure to the approach taken to the initial assessment of general damages. Then we have a look at the key legal principles are included in that work as well. Very interesting, particularly for advocates or for attorneys who are presenting arguments in respect of general damages. Those principles are nicely distilled. I think they're quite comprehensive. We will obviously expand on them if necessary on the website, but I think we've made quite a comprehensive start with those key legal principles. Again, we don't go into really a theoretical or an academic discussion. We look very much at what the courts are actually applying. Where necessary, we will obviously make a comment to the effect that there might be differences in approach, but we are very much driven by what the courts say and do. And those key legal principles will be very helpful in, for instance, preparing heads of argument under pressure or assessing a case initially, how those principles work, contingencies, the approach to general damages. There's a long list of key legal principles we deal with. And then we've got our table of comparative cases. Our table of comparative cases is interesting because we don't just look at the injury diagnosis. We give some sort of context to the outcome diagnosis. And I think the experts will probably understand what I'm talking about, but it means that we don't just have a look at a list of injuries. We try to give some understanding and insight into the subjective context of those damages. And we will hear from Professor Klopper, I'm sure, the importance of that approach. Just before I move off the quantum guidelines, just a summary, there is a very useful video which I've already prepared with Dr. Herman Edeling, who explains the approach which is taken in the quantum guidelines. He's well familiar with the approach, and I interviewed him for about 45 minutes or so, and he went through that approach. Very, very interesting and informative video from the medical side. And we will hear now from Professor Klopper on the legal side what the approach should be. Okay, let's have a look at the training component then. Insofar as training is concerned, that, as I've already said, the specialist training on the 30th of March 2025. Current awareness training is already running and will now pick up momentum next week. We offer that training, as I say, on a weekly basis. We do update it on almost a daily basis, but we offer the training on a weekly cycle. Wednesdays, expert witnesses, and Sundays, legal representatives. The advanced training will be more specialized courses. We've got high caliber trainers, which we'll make available. And as I said, organization driven. For those that are attending, please go back to your organization. Let them know about the medico-legal reports. Let us know what you want us to prepare on. We will work in conjunction with your organization to prepare training, advanced training, and we will work to matchmake the right trainer with the right required training. So as I say, we're in talks with certain organizations already. I'm sure that will expand quite rapidly over the next few weeks. And then just certification, a monthly accreditation for current awareness training. So every month there's a certificate that will go out if you meet the pass mark. We've had a lot of questions from medical practitioners, I think mainly in the expert witness capacity for CPD points. Yes, CPD points will be available for experts and the healthcare training, and we will get those CPD accreditations through the accrediting bodies. The accreditation will be, that's in other words, the South Africa Medico Legal Reports accreditation will be downloadable and shareable through social media. Again, really nice platform to showcase your newly acquired skills. Our approach to the specialist training is needs driven. What is there a demand for? And as I said, we associate very much with organizations with regards to that training. There's then a summary of the quantum guidelines, general damages that has found its way in there. I think that was the wrong slide. Forgive me for that. All right, the next, this just on the awareness platform. Let's just have a look at that in a bit more detail. As I said, internal awareness, multimedia dissemination. Please join our WhatsApp group. You don't even have to be a subscriber. We will send you information via the WhatsApp group. We don't bomb you with information on the WhatsApp group. We prefer to give you sort of more surgical information that you can then go to the website. That's really where everything happens, is on the website. But we will keep you updated when an update comes out once a week, for instance, or an important case, etc. Professor Klopper has been exceptional on that WhatsApp site so far, and we really encourage people, but it's not supposed to be a social platform. The idea is to put sort of technically relevant information out there, so in the form of judgments and the like. It's not really designed to be a discussion forum. And then I beg your pardon. Let's just go back to that. And then we've also got our YouTube channel, which we are in the process of implementing. This will be part of the YouTube channel. That is going to get traction over the next few weeks. Very pleased to have that up. And then, of course, the hub is the website. All right, then let's have a look at the next aspect of the awareness platform. This is the external awareness. So the awareness of the subscriber's knowledge, skill, and experience. Again, the website, shareable, and SAMLR promotions. For instance, where people have done well in their training, we will then do an interview with them and then disseminate that via social media. Okay, let's just have a look then for legal representatives. Let's just address the benefits to advocates firstly. Easily accessible, accurate, and efficient awareness of content not otherwise accessible. Greatly assists in drafting heads of argument, pleadings, and opinions or memoranda. Promotion of knowledge, skills, and experience. Very, very useful. It's basically, you can regard this as a just on the information side as a shortcut to understanding what's going on in all the unreported and then, of course, the MALR reported judgments. Then the next category for attorneys. Again, easily accessible, accurate, and efficient awareness of content. A very important aspect which we've had some interest in, quite a bit of interest, is to keep staff up to date with the current awareness training. Very nice feature for firms. Keep your staff up to date. We'll effectively train your staff and keep them up to date for you. Both current and in-depth knowledge built up, as I say, by being aware of current judgments. Every judgment gives a context to those principles, and that builds up over time. And then, of course, the promotion of knowledge, skills, and experience of individuals and firms through the awareness platform. Let's have a look at the expert component. What are the benefits to experts? Well, of late, we're starting to see that experts are put under increasing pressure from the bench, to be blunt. The lack of involvement by certain defendants leads to judges briefing themselves for the defendant often. And we're finding that unless you have the requisite level of knowledge with regards to the requirements of expert evidence, you can rapidly get yourself into hot water. So again, easily accessible, accurate, and efficient awareness of relevant content. The explanation of case law in understandable terms is very important. You know, there's a judgment now last week. Very, very important that you understand, for instance, the difference between an admission of facts and admission and an agreement on opinion in an expert in a joint minute, and there are far-reaching consequences if that's not understood properly and clearly by the experts and by the legal representatives. And in fact, that case is a good example of where things went wrong at the level of the Supreme Court of Appeal, the judgment by Kitely, which demonstrated that particular weakness. But there are many instances recently. And then, of course, there's also the promotion of knowledge, skills, and experience component. Then let's have a look at the next one, which is the healthcare sector. The regulatory and ethical compliance within the healthcare sector. We've had some preliminary talks with a number of organizations that we've got shelved more for the second half of the year. We'll have a look at bringing that out. Got enough on our plate as it is, to be honest. And that'll be independently developed through MedSecure Pty Limited products and healthcare sector role players. All right, and then just to start heading into conclusion, how can I benefit from the South African Medico Legal Reports professional support system? Firstly, subscribe to the system. Whether you subscribe or not, sign up for WhatsApp and email updates. Alert your professional organization to our request for collaboration. Use our training and accreditation to promote your knowledge, skills, and experience through your personal profile and social media context. And then just to close, just a reminder of the Quantum Guidelines launch. Just want to thank everybody for making their time on a Sunday evening or whenever you're watching this video. I appreciate your time. I'm looking forward to this project. I think it's going to be very exciting and interesting. I'm not aware of any project where there's been an integration of legal information made available, integrated with training with such a strong practical aspect. So we're looking forward to what's already been a very, very absorbing project, and we look forward to growing that during the course of the year. Thank you to everybody for your time. I'm going to switch my video on. All right. And with that, that brings to an end my presentation. Can I then ask Professor Klopper, Professor Klopper, Henny, are you ready with your presentation?
I'm ready.
All right. Can we then proceed with your presentation? I'm very interested to watch it. Thank you very much, Henny. I'll hand over to you.
Good evening, all participants. It's a pleasure and a privilege to be able to speak to you tonight on a subject of which there is very little knowledge, generally speaking, among legal practitioners and even the judiciary. The problem is that this particular topic is never dealt with in any curriculum in any university in South Africa, and neither is it covered in the professional training. So that what happens now, you get the practitioners who enter practice without a decent understanding of what is involved in assessing non-patrimonial loss. Non-patrimonial loss, I prefer this terminology to general damages, because general damages is a catch-all for all kinds of damages, while non-patrimonial loss describes accurately what the loss is all about. And it cannot be damages, because damages are recoverable in respect of physical injury. So that is why I refer to non-patrimonial loss. So that's why I have paid attention to non-patrimonial loss. And all of us that have did articles in the olden days, the first thing that you would receive, first instruction you would receive from your principal, is a thick third-party claim with an instruction, assess the damages. And that was something that was a crisis, because we didn't know whether you were Arthur or Martha when in doing that. And it's also a schlep, because it entails the comparison of a lot of cases. So that's the reason why I did non-patrimonial loss. Now, non-patrimonial loss, the topic can be separated in the following subsections: the general principle of non-patrimonial loss and the object of patrimonial loss. Secondly, the general principles of assessment. Thirdly, the guiding factors that are used in order to assess non-patrimonial loss. Then comparable cases. And then finally, aspects of bodily integrity, how these principles that we have indicated above, how do they fit in respect of, say, pain of suffering, loss of amenities, and all the subheadings of non-patrimonial loss. Now, the general principle with damages is that damages are only recoverable if they can be assessed. Now, with the non-patrimonial loss, there's a difficulty with assessment. With patrimonial loss, it's quite, if you're involved in a collision with your motor vehicle, it's easy to take it to a panel beater. And how much is going to cost you this? But with non-patrimonial loss, because it's a non-physical phenomenon, it is not easy to be able to put a number to an injury. Notwithstanding, our law recognizes that you can recover non-patrimonial loss, irrespective of the fact that it cannot be accurately assessed. Very important, in order to understand non-patrimonial loss and to get an accurate assessment, one must be aware of the object of the payment of non-patrimonial loss for physical injuries. Now, there are authors and the judgments which indicate that the object of non-patrimonial loss is to counter the diminishment or detrimental consequence of a compromise of rights of personality, heightened emotions, feelings, outrage, and loss of happiness. And there are various approaches to this. First of all, there is a personal approach where it's said that the object of compensation is the compensating for the loss of happiness. Then there is a personal function, objective approach, which says it is a non-economic interest, which is considered an asset, like a patrimonial asset. And finally, the personal functional approach, which says that it's the loss of happiness, and that for that amount is awarded to a solace, consolation, and to neutralize the effects of personal injury. If you're interested in this, you can go and read Ogus. It's quite enlightening. And the case law on this point, you will see the case law that I have noted for you on this point. Now, in our case law, it's mostly the personal functional approach that is applied. That is, it is considered to be a loss of happiness, and an amount to counter the loss of happiness is then framed and assessed to make sure that the person receives consolation for what he's lost, although it can never ever take away what the experience was, or the negative experiences of the injury. There is some misconception of what the basis is for a claim for non-patrimonial loss due to physical injury. Now, if one considers the legal position, you will see that the actio legis aquilia is that action in law and with which you recover non-patrimonial loss. On the other side, you can recover non-patrimonial loss by utilizing the actio injuriarum. But the actio injuriarum is only in respect of intentional infringements of rights of personality. So that when you consider a personal injury, you cannot recover damages for personal compromise of the physical integrity if that had occurred negligently. So in order to cater for this position, the courts and our courts have developed a special action called the action for pain and suffering, which is an action specially devised in order to allow a claimant to claim for non-patrimonial loss, which was inflicted negligently. And this is actually a development which was triggered by motor vehicle collisions, mainly. Now, when in assessing this amount, the court, as in all damages assessments, has got a wide discretion to determine what a reasonable amount, a fair and reasonable amount would be for the particular injury. You can look at those cases. Those cases reflect that principle. The main consideration is it must be fair and reasonable on the facts. Very important, on the facts and in the circumstances. I am involved in reporting non-patrimonial loss cases on a quarterly basis, and I see many cases that are decided where there is just a injury comparison. No attention is paid to the circumstances of the claimant or what his position was prior to the injury and what the consequences of that injury was on his personal situation. The judge must also provide the factors and circumstances deemed important and must provide a reasoned basis for his conclusion. This also is absent in many of the cases where non-patrimonial losses loss awarded. I think the reason for this is because in the context of claims against the Road Accident Fund, many of these cases are decided on a default judgment basis, that where there is a lack of information from the RAF side to give a clear picture of the consequences and exactly how the injury affected the claimant. The other principle is it must compensate and not overburden the defendant. You'll remember the Horn of Plenty judgment, Pitt versus Scrimgeour. It must be done with compassion, and if there is any doubt, they must err in favor of the defendant. And finally, it must be commensurate with other awards made in other cases that are comparable. Now, the reason why comparable cases are used is in order to ensure even-handedness, so that compensation is awarded for like, so that there is not, you don't get a situation where one claimant is favored above the other. And that's why comparable cases are important. Now, the object of the compensation is to compensate for the consequences of the injury. In many of the cases that I see, the injuries are compared without having regard to the consequences of those injuries. So the claimant's situation prior to injury and the claimant's situation subsequent to injury is given scant attention. And there's a concentration saver. A suffered a femur fracture, B also suffered a femur fracture. A spent 3 days in hospital, B also spent 3 days in hospital, and that kind of approach, which is not the right approach. It should be the consequence of it, because the object is the restoration of the mental and physical well-being. Now, how can you restore and award damages without knowing what the consequences of the injury was? It's impossible. And also to provide solace for the unhappiness and overcoming of the consequences and assuage or overcome wounded feelings. And this is done by the payment of money, and so far as money is capable of compensating for those types of factors. It must be commensurate with the injury and its consequences, and in doing so, the nature, intensity, duration, and personal profile of the person has to be taken into account. Now, as far as this is concerned, whenever you read a report where there has been this assessment of non-patrimonial loss, it starts sometimes even after the claimant has been discharged from hospital. Now, as a third party claimant myself, I can vouch for the fact that does not reflect the true situation. The shock and the pain on injury up to where you get admitted is a factor that is disregarded in many of these cases, and it is something that must be taken into account. You have to, there are certain guiding factors that you have to take into account: the age, gender, lifestyle, culture, race, and consciousness of pain. Although race doesn't play any role in the assessment of the damages. Age can both ways. Young people and older people can experience pain more intensely. Gender as well. Women, I would venture to say, have got a higher pain threshold than men, and the consciousness of the pain is very important, because you can only recover pain and suffering if you experienced the pain and suffering consciously. As far as pre-existing physical and mental conditions are concerned, there is an approach in practice, found an approach where the experts are inclined to say, well, this person had a slip disc vertebra, and he got injured, and there's now a question of are his complaints ascribable to the injury or to the previous existing condition. Essentially, this is a question of causation, but then there is a legal principle of take your victim as you find him. So the RAF is not entitled to rely on the fact that the person had a pre-existing condition in order to escape liability for compensating that particular injury. And the injury should be ignored, especially if at the time of the injury, the claimant was asymptomatic. If he had no symptoms of his current complaint quite before he was injured in the collision. And generally, it should not influence an award. The practical approach is to apportion causation and say that the previous existing injury caused 30% of the current complaints and the crash 70%. Therefore, the claimant is only entitled to 70%. The fallacy of that argument is quite clear. The only thing that can be apportioned is negligence. Causation cannot be apportioned. Once a claimant has shown on a balance of probabilities that there is a link between the crash and the injury, he is entitled to all the damages, the reasonable damages flowing from that injury. What happens if a claimant dies after his litis contestatio has been reached? You will know that because of the fact that the claim for pain and suffering is a personal claim, that claim dies with the claimant unless litis contestatio has been achieved. Now, litis contestatio is a stage in the pleadings where the last opportunity for the exchange of pleadings has lapsed. So once that is done, then the claim has then been formalized, and therefore, when the claimant then dies, it transmits to his estate. So how is this assessed? Because in assessing the non-patrimonial loss, the life expectancy of a person is important, because if the prognosis is that that person is going to have a continuing troubles from his injury, chronic troubles from his injury for the rest of his life, the principle of intensity and duration then kicks in, and one needs to determine the duration in order to assess the damages. Is the duration now the duration up to date of death, or is the person's life expectancy? It is not the life expectancy, it is ignored. So on those circumstances, you take the experience of the claimant up to the date of his death and not any further than that. I've referred to even-handedness. The other principles is that a court is not allowed to deviate from a previous comparable case without giving adequate reasons. As I said, it ensures fairness, reasonableness by preventing discriminatory awards for similar injury. You can go look at the case law that I've quoted there. And in doing so, we have to adhere to the principles of comparison as framed by the Supreme Court of Appellate Division in order to ensure that the comparison that you are doing is valid. Reading the case law, you will see that there is an approach that says the general award and not every detail is taken into account. So you must look at the general trend of that particular injury and the consequences, and look at your client's situation, compare the two, and see to what extent do these two cases agree with each other, and what extent do they differ. This is a guide, and it does not exclude the court's discretion. Very important. This is a principle that has been stressed in De Jong versus Dupusani in paragraph 64. The facts must be identical. Now, I've got a problem with this, because if one reads the case law, you will see that there is just a cursory comparison of the facts without finding common ground between the case that is being considered and the case that was decided. Now, as far as I'm concerned, the quote out of Goliath is, in my view, the policy to follow, where it says, moreover, to ascertain whether particular cases are similar in material respects, the facts in regard to the degree of pain suffered by the claimant in each particular case and the amenities of life which he was deprived of must be shown, but known before a comparison is justified. This would entail at least a study of the full judgment in each case. Mere knowledge of the nature of the injuries will not be sufficient. And this I must stress. Knowledge of the injuries is not the point. It is the consequences of the injuries that have to be considered. The principles of assessment still valid. In other words, the court has got a discretion in order to determine which factors it will take into account in order to determine a reasonable amount. And this can be tested by referring to non-comparable cases, the awards in a pattern. If the cases aren't completely on all fours with each other, one can look at those cases which are not on all fours to see whether the award that you are propagating or advising is within the limits of the awards in non-comparable cases. Award may not be striking disparate with a previous award. If so, that will be appealable. There was cases which said that there was an upward tendency in non-patrimonial loss awards. It started off with Wright versus Multilateral Motor Vehicle Accident Fund, and it was perpetuated in Marunga's case. So in Wright, the judge said that according to modern society and the current contemporary view, the awards that were handed down prior to this case were too conservative, and he upped the award. And he also referred in the process to foreign case law. Now, as far as the foreign case law is concerned, Ian has already referred to the fact that the currency differential makes that particular comparison very, very, very unreliable. And in other respects as well, is that the factors taken into account in other jurisdictions do not necessarily accord with the factors that are considered in our case law. So that going to foreign case law and foreign judgments in order to justify an amount is an exercise which I do not recommend. This particular upward tendency in Marunga resulted in people arguing, say, but listen, the judgment granted in Wright was proportionately 33%, as arguments for argument's sake, 33% higher than that of the previous case law. So all other awards, subsequent awards, must be adjusted mathematically by 33%. And this was rejected in Marunga's case by the Supreme Court of Appeal. And in De Jong, it was established and confirmed that the upward tendency is just but one consideration which the court needs to take into consideration when dealing with this particular matter. Finally, when you have established the amount, it has to be adjusted for inflation. And in this regard, the courts have accepted that the consumer price index is a valid expression of inflation. And what needs to be done is to determine the pro rata increase between the base compared case and the case that you are and the case and the amount that you are now currently assessing. So it will be the CPI, the highest amount. The highest amount is the current CPI divided by the CPI of the original award, and then multiplying that with the award of the original case. Just a word, I have looked at quantum of damages, and there seems to be a discrepancy between the amounts found in Koch's Quantum Yearbook, which is a publication which on an annual basis updates all the awards made since 1947, I think, or 57, and that there seems to be a different formula being used by quantum of damages. Now, the courts have, by and large, accepted Quantum Yearbook as the measure of increase of these damages, but I've also seen cases where the amount suggested by quantum of damages have been accepted by the courts. Then there's a factor, especially when you are dealing with quadriplegics and paraplegics, where paramedical aids are awarded as part of patrimonial loss. Now, that award can have an influence on the general damage or the non-patrimonial side of the award, because the non-patrimonial side is awarded in order to alleviate the loss of amenities, while the aids that are awarded in terms of the patrimonial loss have got the same effect and object. So when there is such award of aids, one must to consider to what extent does that have an influence on that person's loss of amenities? Does it improve, and to what extent does it improve, so that you have to adjust the award accordingly. Also, if there is an improvement of medical treatment and equipment, which can have the effect of ameliorating a person's position in respect of his loss of amenities, this needs to be considered when doing so. Then this brings us to the aspects of bodily attenuation. Here one can identify certain aspects. First of all, I must emphasize that these are not separate heads of non-patrimonial loss. So what I'm trying to say is that when you assess damages, you do not say if you've got multiple injuries, you've got a head, you've got a shoulder, and you've got a leg. Go and look for cases where there was a head injury and a leg injury and a shoulder injury, and then take the awards and add them together, and then take the average, or any similar sort of approach. That's not the way that it's done. The injuries are taken collectively, and taking the awards for body parts that are involved into consideration, the court has to frame an amount which it finds to be fair and reasonable under the circumstance, and then has to award one lump sum as compensation. I remember recently in a Free State case, a acting judge doing was it in Limpopo? I think it was in Limpopo, where the judge said, okay, this guy had a arm injury, and he had a shoulder injury, and he had a lower leg injury, and these are the awards, and he added them together, and he awarded compensation accordingly. There are the following aspects to bodily integrity: pain and suffering, emotional shock, disfigurement, loss of amenity, shortened life expectancy, and loss of health. The first one is then pain and suffering. Now, what is pain and suffering? That's the general discomfort and shock resulting from bodily injury. So one can look at Sigourney in all these cases, and you will find that that is how that is formulated. It includes psychological suffering, trauma, or anguish caused by physical injury, precisely because the body is a unitary concept, and that the psyche cannot be divorced or separated from the body. And for that reason, psychological injuries are also included as under bodily injuries. It includes that which is the pain and suffering caused by medical treatment. And as I said before, this is why it is important to trace the person's medical history, exactly to what extent did it have an effect on his pain and suffering, on his discomfort, and how did he cope. And while I'm on the topic, when looking at the medical records, the fact that the person was admitted while he was unconscious is an important factor to note, and should not be ignored. I'll come to that a bit later. So anxiety, change of personality, depression, withdrawal from social activities, PTSD, all those kind of things are included under pain and suffering. Post-traumatic stress syndrome. Are all psychological injuries recoverable? It need not be identifiable, but must be factually supported, and it can be uncategorized for psychological injury. Especially this case of Maloney can be noted, where a person, like in the case of Saul's, committed suicide as a result of his injury, and the court held, or the courts or first instance held, that because it was not identifiable psychological injury, the dependents did not have a claim against the road accident. It was overturned on appeal. The degree of depression, plaintiff's vulnerability, and general psychological sequelae of the physical injury is taken into account. And then here's the point. It must be consciously experienced. So if a patient was under heavy sedation, that he was not aware of his pain, then that must be disregarded. And the periods of his unawareness of pain has to be noted in order to determine a reasonable amount for pain and suffering. If the person is in a coma, then for pain and suffering, a person does not have any claim for pain and suffering, because it must be consciously experienced. If a person is in and out of a coma, then those portions where he was aware of the pain are taken into consideration consideration. Now, you understand, in order to prove this, one needs the evidence of the claimant supported by expert evidence medically. The race, financial status, and circumstances under which the injury was concerned is ignored. So if a person was extremely negligent in injuring a person, a claimant, that particular factor is not taken into consideration when framing an amount for non-patrimonial loss. It is a subjective experience of the person in the first instance, and this is determined by obtaining the duration and intensity of the pain. And the only way of doing that is to get evidence from the claimant and also of persons who witnessed his recovery and saw to what extent he did have pain. A factor that can be of assistance is to look at the prescriptions that were given to the claimant, to what extent were analgesics prescribed, the strength of the analgesics and the period for which he took pain-killing medicine. The ability to tolerate pain is disregarded, and this can be proven, as I said, by the claimant, family, and expert witness. So you've got the subject aspect, which is the evidence of the claimant and his family, and then the objective expert, which is then formed by the opinion and the report of the doctor, the medico-legal report. As far as psychological is concerned, is the degree of depression, vulnerability, and general consequences of the injury. To what extent did that impact on his life, his social interaction, his personality, all those kinds of things. This brings us to emotional shock. Now, emotional shock is a psychological injury which a person can suffer without being physically involved in the collision. It entails the negative consequences, the negative psychological consequences of becoming aware of an unpleasant, of a disturbing event, such as a death of a person with which the claimant had a close personal relationship, emotional relationship. The requirements, just to recap, it must be sufficiently serious, it must be reasonably foreseeable, and there must be a close emotional relationship in order for it to be recoverable. The symptoms are amnesia, insecurity, instability, inability to socialize, sleeping patterns, lack of self, depression, and anxiety. And the amount is determined once again by the severity and the duration. One must remember that a claim for emotional shock against the RAF is excluded by Section 19G, but only in respect of persons who were not involved in the collision. If a claimant was involved in the collision, let's take an example. A claimant is involved in the collision and witnesses the child witnesses his parents dying while he was trapped in the car. Then under those circumstances, that child will have a claim for emotional shock. If in the same instance, the sister of the deceased is advised of her sister's death in the collision, and she has a adverse experience, psychological experience, that claim will lie against the negligent driver, not against the road accident fund. I do not agree with this, but that is the law. This brings us to mutilation. Now, mutilation concerns aesthetic aspect of a person. It's facial and body, loss of limbs, limping, facial contortions, and contorted limbs. And it also takes into account the psychological consequences arising from the difficulty with socializing, the loss of self-esteem, and the unhappiness and the stress caused by the person's personal appearance. It can also affect a person's work life. If a person's, for instance, a receptionist at a business, and the disfigurement makes his interaction with the public difficult, then it can be a problem. And the first example that comes to mind would be that of a model. The fact is the degree of the visibility and the stage of development of the person, the personal and social and situational characteristics. Was he a very sociable person? Was he outgoing? Was he recluse? Or what was his situation? The person's personal appearance prior age and visibility of the disfigurement, whether he had a sensitive disposition. Gender, females are generally awarded more than males, and the impact of a person's working life. The awards are generally conservative, but if serious disfigurements are given a higher award. Now, if a person suffers, if this award is to be considered, normally you will find it is considered in conjunction with pain and suffering and loss of amenities, and that disfigurement is not separately compensated unless the disfigurement is of a very serious nature. If a person, if the medical legal report says that the disfigurement can be improved by plastic surgery, it must state to the extent to which it can improve, and then if the improvement will still result in residual disfigurement, and then if the residual disfigurement must be stated where it's quite obvious, or where it's hidden, or what the situation may be. Loss of amenities of life. This is any aspect of a person's normal life that was affected by the injury, making it difficult, impossible to resume all those activities that he took part of prior to injury. So it can be recreation, can be self-care, it can be social events, or playing golf, or any sport, sexual activities, impotence, all those kind of things are considered to be loss of amenities of life. Partnering prospects as well. In this case, we had Gibson versus Berkowitz, and also Sigourney versus Gilbanks, marriage prospects. Further, general health. If a person is affected to the extent that he is continually having to consult with his medical advisors subsequent to his injury, and he is not recovering fully, then this is something that has to be taken into account when dealing with loss of amenities at the same time. If a person's life expectancy is affected, then the anguish and the normal unhappiness caused by the knowledge has to be compensated. How is this established? It's by the medical evidence and actuarial tables. And of course, the shorter the person will live, the higher the award would be. And it's considered part of loss of immunity. And finally, loss of general health, I've already referred to. Which is the last topic. But before we get to that, what is the situation with loss of amenities if a person is in a permanent coma? Because if a person is in a permanent coma, the object for the compensation cannot be achieved because the person is unaware of the fact that he's being compensated. Now, there are divergent approaches to this, which has started with the case of Collins, where it says because a person is unaware of the fact that he's being compensated, he's not entitled to compensation. But then on the other hand, if one distinguishes between pain and suffering and loss of amenities, then it's clear that for loss of amenities, it's not necessarily required for a person to be aware of his situation, because in the case of a coma, a person has suffered total loss of amenities. So on that basis, one cannot just say that he's not entitled to compensation, but that when you award compensation, the fact that he's unaware of the compensation has got a mitigating effect on the amount. In recent case laws, and I'm referring to Boyce's case, the judgment of Collins versus administrator was ignored, and award was given irrespective of the fact that the original claimant, was in a coma. I've dealt with loss of general health. Now, here is sort of a checklist that I think one can fruitfully use when dealing with loss of dealing with compensation of non-patrimonial loss. Get the biographical information, age, gender. It's quite surprising in many judgments that you do not know what the age of the person is. In some judgments, they don't even mention the sex, nor do they list the occupation of that person. So you look at the person's personal character, the person's psychological profile. Very importantly, activity of living engaged prior to injury, and the current position regarding living activities, so personal and medical consequences. Identify the major injuries and list the subsidiary injury. So what are the major complaints, and concentrate on those, taking the subsidiary ones as ones that add to the person's compensation. Obtain treatment details at the scene of the action, important. How was he transported? Did he walk to the hospital, or was he transported by ambulance? The treatment or ambulance, such particulars as the Glasgow Coma Scale and other treatment details, whether he was unconscious, if he was unconscious, for how long was he unconscious, when did he regain consciousness, did he have amnesia, what kind of amnesia did he suffer from, how long was amnesia, was there any complications while he was in the hospital, how was the complications treated, how did that impact on his stay in the hospital, did it cause extra pain and suffering, etc., etc., etc. All those details are required. Now, when you look at the judgments that are reported or that you read, that are being noted, you will see that the details of complications are just mentioned in passing. So a person who has had a ununited fracture and had to have, say, 4 or 5 bone grafts, the fact that the fracture has not united and that he had bone grafts are mentioned, but the effect or personal effect on that person of that experience is not noted. And that should, because it's all part of the non-patrimonial loss that that person said. An indication of person's severity of injury is the period of hospitalization. In modern times, the hospitalization periods have decreased, but nonetheless, if one looks at, compares the injury, the period of hospital is an indicator of to what extent that do the injuries, do they compare or not. And then impact on life and mobility and subsequent to trauma, both physically and mentally and psychologically. Also the subsequent treatment. Also, one must then establish the medical consequences of the injury. Is the person going to suffer from epilepsy? What is the prognosis? Is he going to require hip replacement? What are the consequences going to be of the hip replacement? How painful is it going to be? How long will he be in hospital? How long will he suffer the pain? All those things you need to know in order to make a valid and accurate assessment. Obtain a medical legal report supporting the client's subjective report of his experience of his injuries. That's very important. And now, just for interesting sake, this is what a person would look like if he had to survive all road traffic crashes. I thank you for your attention. I hope I haven't been too repetitive or too boring. It's been a pleasure to be able to address you on the subject.
Thank you very much, Henny. All right, fantastic. Thank you very much. Very interesting, useful presentation. Enjoyed that a lot. We're going to move on now to Advocate Ross Shepston. Ross has been at the Joburg Bar for some years. Ross will introduce himself, just give you a bit of a background to himself and his practice. And Ross, it's good to see you again. You know, we've done a few of these together now over the years. I've known Ross through his father, Steve Shepston, now. Well, I've known Steve for maybe 20 years. I've known Ross now since more or less since lockdown. But Ross, great to see your face again and to have some contact with you.
Thank you, Ian.
All right, Ross, I just want to, I invited you on because there was a matter that you were involved in, which dealt effectively, one of the matters that found its way into the medico legal reports dealt with a firm of attorneys who were sued for professional negligence. And I thought, you could maybe just take us through that area of the law and give us just a little bit of context to that case. But I think introduce yourself first, and then let's hear your comments on that matter.
Thank you, Ian. And before I begin, congratulations on the launch of your project, the medical legal reports.
Thanks, Ross. Yeah, no, this is going to be an exciting project, and we've got lots going on in the background, lots of developments, and tonight's an important milestone, but we're looking forward to this going forward. Thanks very much, Ross. No, it's going to be good.
My background is I'm an advocate. I've been a member of the Johannesburg Bar for 25 years. I do all types of cases. I do commercial work as well as personal injury litigation. In my personal injury practice, I have done all types of cases, including road accident fund cases for both plaintiffs and defendants. I've also done what is called PRASA or train cases. There I act mainly for plaintiffs. I have done a lot of medical negligence work, mainly, once again, for plaintiffs. And as Ian said in the introduction, I also do claims where I defend attorneys against professional negligence. And it's in those matters, about those matters that I want to speak to you tonight. This is not going to be a lecture. I'm not going to lecture you on the elements of these claims, but I'm going to speak in very general terms as a practicing advocate about certain practical elements of these cases. Now, you would imagine that in cases where attorneys are sued for professional negligence, the stakes are very high. Number one, the attorney is facing a financial claim for which he is insured, but for a lot of these matters, the indemnity which the attorney has is far less than the amount that is claimed. For example, if you have a plaintiff in a RAF case which has suffered a brain injury, and the attorney allows that claim to prescribe, then the attorney is facing a claim of many millions of rand, which will then exceed the limits of indemnity that he has with his professional insurer. And number two, and most importantly, the attorneys are then also can also suffer reputational damage. And it's here where one has to be very careful in the way that you defend these cases. And in more cases than not, it is probably better not to litigate the negligence part of the claim. And I'll speak a little bit later about the two parts of each of these professional negligence matters. There are two different causes of actions in these claims. One is based in delict, the other is in contract. The normal elements of both of these claims are well known to most practitioners, so I'm not going to go through them. But one of the most important aspects of these claims is the element of causation. And here the plaintiff must plead and prove that the negligence of the attorney in fact caused him or her to suffer damages. So it's not good enough to only plead or claim that an attorney is negligent. That's what we call negligence in the abstract. You must go one step further, and you must prove that the negligence of the attorney actually caused you to suffer damages. And in order to do so, you have to, as a plaintiff, prove the underlying claim, what we call the underlying claim. You have to prove that in your original action, the action which you have now lost due to the negligence of the attorney, you would have, on the balance of probability, succeeded with that claim. And you would have been successful, and you would have been paid an amount of money. Now, there are many types of professional negligence claims against attorneys, and I'll just mention a few. One, there are many claims against conveyancing attorneys. These claims arise because the conveyancing attorney does not do a proper due diligence. They don't make sure that the person who is signing on behalf of a company or a close corporation, for example, has authority to do so. That's one type of claim. There are claims based on the failure to know and apply the law. I was involved in a case where an attorney had agreed on a stated case, but had failed to take proper instructions from his client and had made allegations or averments in the stated case which were not correct. His erstwhile client then sued him for damages due to negligence. There's also cases based on negligence for the attorney's lack of preparation in whatever cases he is litigating on behalf of his client. In RAF matters, there are cases which involve the under-settlement of cases, or cases which involve settlement without the authority of the client. And one fertile ground for these types of claims is obviously prescription. And in those matters where the attorney allows the claim to prescribe on his desk, in most of those cases, the attorney is then negligent. And then what happened is that you must then decide whether or not to either settle the claim or to defend it, based on whether or not the plaintiff would have succeeded in the underlying claim. Now, this is where these matters for professional negligence or professional negligence of attorneys are interesting. Because in fact, you are litigating two separate cases. The first case you are litigating is the negligence claim against the attorney. So an attorney now has to face his erstwhile client, and that erstwhile client is now claiming or accusing the attorney of negligence, and you then have to defend that claim. The second trial is what I've referred to as the underlying claim. You can call it the original claim or the cause of action that the plaintiff lost due to the negligence of the attorney. Now, in personal injury cases, for example, you'll have a plaintiff that mandates an attorney to sue the road accident fund for injuries that that plaintiff suffered in an accident, and he suffered damages. The attorney then allows the claim to prescribe. The plaintiff then goes to a different attorney, and then an action is then initiated for professional negligence of the erstwhile attorney. Now, in that case, you have one, the negligence case against the attorney, and that must be litigated. And then interestingly, you also then have to litigate the underlying claim. So you must run the trial, or the plaintiff must run the trial and prove the elements of his cause of action against the road accident fund. And that is what we call the litigating of the underlying claim. What is interesting about litigating the underlying claim is as follows. When an attorney notifies his insurer that there's a possible claim against him or her, the first thing the insurer does is to ask the attorney, who is then called the insured, to hand over his case file. Now, that is the file relating to the underlying action. In that case file, the attorney will have his consultation notes, he'll have memos, he will have every single aspect of the litigation noted in that case file. For example, there will be discovery affidavits, the pleadings, internal memos between the attorneys and staff within his firm. As I said, the consultation notes with his erstwhile client who's now suing him. And that file is then discovered during the litigation. Now, you will just imagine what fertile ground that file gives the defendant's counsel or even the plaintiff's counsel for cross-examination. A plaintiff is now suing his erstwhile attorney for negligence, but the original consultation notes are now known to the defendant's advocate, who then can cross-examine the plaintiff based on the notes that he has before him. But it is also a double-edged sword, because the attorney's entire episodic memory, if I can call it that, of the case from beginning to end is noted in the case file, in the court file, if you want to call it that. And if the attorney was negligent, it will then be quite easy to pick up where he was negligent in his own notes. So that is an extremely interesting part of these cases for professional negligence against attorneys. As I said, there are two separate trials which one must litigate. In the underlying claim, you must prove that but for the negligence of the attorney, I would have succeeded in my claim against the RAF or whoever the defendant was at the time. And there the element of causation comes to the fore. you must then not only prove factual causation, which is a but-for test, but you must also then prove legal causation. And that must be proven on a balance of probabilities. In order for a plaintiff to prove that he would have succeeded in the underlying claim, he obviously has to give evidence. And then he'll be cross-examined, I beg your pardon, by the advocate for the defendant, for the insured. And that advocate, as I said, now has the consultation notes in his hand, and where the plaintiff then deviates from the consultation notes, i.e. where he now gives evidence contrary to what he told his erstwhile attorneys, then that will be dealt with in cross-examination. And it might cause, and in a few cases that I've been involved in, it has caused the demise of the plaintiff's case on the underlying claim. Also in the underlying claim, if it's a motor vehicle accident, the plaintiff will have to prove negligence, etc., same as he would have if he was litigating against the Road Accident Fund. He will have to call experts. In a lot of these matters, there are accident reconstruction experts that are called to give evidence of how the accident occurred, and that evidence then is weighed up against the eyewitness testimony of the plaintiff and his other witnesses that were involved in the accident. Also in these matters, you require the expert evidence of medical experts. Number one, it is important to show that the injuries that the plaintiff has suffered are causally related to the collision itself. So the element of causation and the underlying claim is also important. And you must also obviously prove the defendant's non-patrimonial and patrimonial damages. And that is why one would call experts in these cases. Yes, so in the South African medical legal reports, there is a case in which I was involved. That matter relates to a claim, or the underlying claim was a claim against the Road Accident Fund. In that matter, as I said, there are two cases, the negligence claim and the underlying claim. What we did is that we separated the underlying claim from all the other aspects on the pleadings. And that is what's usually done in these matters. As I said, you don't really want to run the negligence claim because that's where the reputational damages against, or damage against attorney can occur. So we separated the underlying claim from all the other aspects on the pleadings, and we ran the underlying claim as a separate trial. In that matter, the plaintiff had given detailed instructions to his attorney, his erstwhile attorney, who's now facing a negligence claim. And those notes were then given to me in order to cross-examine the plaintiff himself. And in various respects, his testimony then deviated from what he had originally told his attorney in the original or the first consultation. So that's why I said it makes these cases very interesting, in that the attorney who formerly acted for the plaintiff is now his adversary. But not only that, he also has some ammunition that he can use against his erstwhile client.
Ross, thank you so much for that. Very, very informative. Yeah, these cases, as you say, can be complicated. You're running two trials in one, as if one is not complicated enough. You've got two, you've got to keep, and then they're also, and something you touched on, and I've run a few of those trials myself. One thing that I just want to emphasize from a sort of practical perspective, the pressures on the advocate, because you're dealing with an entire firm of attorneys' reputation, And, for instance, in this match that's been reported, you've got a young, often you've got an individual that's now having the finger pointed at them. You've got somebody's whole career in your hands. It can be a very stressful experience. You feel that, I feel that duty quite keenly, so it's one of those types of cases that just a bit of a high pressure type of case.
And as I said, what happened in that matter is that we separated the underlying claim from the other issues on the pleadings. But for some reason, the judge found it necessary to deal with the negligence aspect, which wasn't relevant, which wasn't an issue that was put by the litigants to the judge to determine. But for some reason unknown, the judge deemed it relevant to make some comments regarding the attorney's.
Yeah. All right. Thank you very much, Ross. Appreciate that.
Thank you,
can I just call on Conrad Mashelwane now? Conrad, if you can please tell us, just firstly, let's just welcome you. Conrad, great to see you again. Last time I saw you was at that big function that all you medical people have, that get together of yours. So it's great to see your face again, Conrad.
Thank you, Ian.
I'm going to put my earphones on here because I can hear a little bit better. Conrad, when I met with you when we were up in Joburg, you were, I think you guys have fairly recently formed the GMG. I think maybe just give us a little bit of an insight into what that is and what you formed.
Yes, just to introduce you to the attendees, I'm Conrad Mashelwane. I'm a gynecologist in private practice. I've been in practice for about 22 years now. And I'm also chairperson of the Gynecology Management Group. We call it GMG, which is basically a business consultancy for independent obstetricians, basic in private practice. And our focus really is advising gynecology in private practice on practice issues. Our billing system is quite complex. We've got basically a language that we use to actually bill patients, and the language is standardized for the entire industry so that people can understand. So we call it a coding system. So we actually have to develop a coding language for doctors to bill. Like if it's a hysterectomy, there's a code for it. And there are certain billing rules and guidelines. It's basically almost a separate field on its own. We have people who actually specialize. They're called coders. And they actually advise us. And we also obviously have to get the descriptors for these codes from the doctors. We also advise them on pricing. Medical pricing is also very complex because, we've got ethical guidelines and we have to be able to justify our pricing. So we helped doctors develop a private and ethical pricing system. I think the last issue that we deal with, probably the most important, is issues we deal with contractual issues and contractual disputes. Our doctors get into many relationships with hospitals, with patients, with funding industry, with managed care organizations. And a lot of things that what actually occupies us a lot is a contractual dispute. Over a lifetime, a gynecologist will have will get summons 3-4 times. But that consumes a lot of your career. Dealing with a summon, it can take almost 6-5 years. And for us, I can relate to Ross in terms of Ross advising a private, assisting an attorney being sued. And I can see the comparisons. It's quite similar. The quantums are very high for an individual. For RAF and Department of Health, they've got billions of rands. We have to be insured, and our insurance can run to like 100,000 rands a month for an individual. Very expensive. Many doctors are becoming uninsured now. And also the reputational damage that the risk of reputational damage that Ross spoke about. But the big issue for us is the psychological stress. you know, there's a lot of, when complications occur, there's a lot of guilt from the practitioner. And doctors tend to judge themselves harshly. I've got a 70-year-old gynecologist who had a TIA. He got summons. He got a TIA, he got a stroke and a heart attack. It's really quite stressful. And for the reason that we get, I'm not a lawyer, an attorney, so we now have to advise our members. And language, legal language is a serious barrier. It's really, I mean, to explain to somebody what is a summon, what is a plaintiff, what is a defendant, this language that you as attorneys take for granted, for a doctor, it's really like speaking Chinese. And the pleadings, what is a plea? What is an action? What is negligence? All these things that we have to deal with. And that's why I'm excited with the South African Medical Legal Report, to really have be able to explain case law in understandable terms. And if we can, I mean, I've read some case law, 30 pages of legal language. It's really difficult to digest. Even the grammar of the law, the styling of it's really difficult for us. And I think if we can get access, I can get personal access to the South African Medical Report, it would be quite exciting. So basically, we've also have, I think for us, medical risk is it's almost a field on its own. We've actually at GMG started a project called Medical Risk Society, where we want to deal with, as you're saying, you are not trying to guide people on what the law should be. You want to educate people on how the law functions. And this is basically what our mission is to make people understand how the law functions as it is, the case law. And so I think that's basically what consumes a lot of my work, is really advising doctors on these medical negligence issues, where literally sometimes I have to go through summons. And a lot of doctors, what happens, they get summons, they get confused, they don't even read them. So we basically we get into an exercise now of going through the summons ourselves, because also the attorney defending the doctor as well, he doesn't have the medical knowledge. You know, he relies on his own experts, and there's also the medical practitioners don't trust your medical experts. And I think there's a name that we use, that there's a name that's used to describe, but basically they doctors.
Conrad, are you thinking of the hired gun? The concept of the hired
gun, yes. So
Prof. Laram has just left us. He wrote a well-known article called "Beware the Hired Gun." Yeah. He would have been very pleased for you to make that comment.
So I think basically, I hope I'm giving you a good introduction of
Conrad. You know what I wanted to just pick up there on, just a point that you wanted to, the thing that I find very interesting is your comments about, I mean, how are you guys supposed to understand what's happening in the law reports? Now, it relates to sort of pure healthcare practitioners. That's a particular problem on its own, which you're highlighting. Expert witnesses are at the cutting edge now, and they even more so. Well, it's both of you, but expert witnesses, to have an understanding of what's contained in the judgments and to read those judgments can be difficult. So it's this is where what we want to do is to simplify what's being said. Let's get the principles clear, and let's get some training that assists practitioners with their daily practice. And that's really what it is, like, in a way, demystifying the legal process and getting those clear, simple principles out and commonly available.
Yeah, so I think basically I'm really interested in the training. For example, I do some work as an expert witness, but the work is really ad hoc. But I mean, my work as as an expert witness actually assists me in actually advising medical practitioners when they've got a case. So I think personally for me, there's gain on both sides. As I can gain as an expert witness, and I can also gain in my advisory capacity for medical practitioners. And
No,
just
excellent.
to
Yeah, and
summarize
Conrad,
case laws, yeah.
I know your work that we've done sort of over the years, very, very interesting, and I really wish you all the best with your endeavors as well. And we will have many conversations about these topics and the common way forward. I just wanted to say to everybody, we are at 9 o'clock. We're going to call it unless there's specific questions. We have a presentation by Dr. Advocate Ferdinand Kerhan, which has been video recorded, pre-recorded. So we'll put that on the YouTube channel. And then these videos, we will also edit this session, get it into a shorter video, and then we'll distribute that through social media as well. And I'm sure we get quite a few views that way. This is our first session. We were concerned about technical aspects, that it would work well. We've had a lot of interest expressed in the session. I'm very grateful to those of you that have made time on a Sunday evening. I really appreciate it. And I think we're going to get a lot of views online as well. And then also on our YouTube channel, which we will grow. And then at the end of February, we've already got quite a lot happening around those quantum guidelines, and then the specialized training at the end of March. So I think for the next 3 months, it's going to be very interesting. I thank all of you that attended and for showing the commitment. If there are any questions, just type them in the question box. If not, then please feel free to get hold of Linda if you want to ask questions privately, and we will be in contact soon. Thank you very much to everybody, and thank you for a great evening. Thank you.